Today in our Toil and Trouble slot, I'm talking to DLA Piper partner Carl Blake about a recent Employment Relations Authority case in which a verbal promise was tested. While that verbal promise didn't pass the test, the authority sent a clear reminder to employers that verbal contracts are as legally enforceable as written ones. Carl, you haven't seen this message for a while.
No, it's a timely reminder that we've been bogged down with a number of disputes. We've talked about changes in government policy and where things are heading, but this is more of a back to the future in the sense of, okay, well, let's look at some core principles of what happens if there's an employment arrangement and someone asserts that they're entitled to something that was never in writing. Mm-hmm. And it's a bit different. So the facts of this case are a little bit unique in the sense that we've got a situation where at a team induction on a team's call, so it's virtual, there is alleged by an employee to be a promise made by the CEO that should an employee bring a good idea to the company that is profitable or makes some money, then they'd be entitled to share in that profit. To the point reached where the employee felt that he had brought an idea in the form of a software program to the company's attention. His view was that if the company adopted that program, they would stand to make millions over the next 5 years, and he felt that his share of that should be about $3.8 million. So immediately when I was reading this case, I started to get a few alarm bells as to the viability of that. And as you've already noted, the authority didn't find ultimately that there was that promise, but it did have to slice up what the actual facts were. And that included what you would expect, the corroborating evidence. Well, who else was on the call? What did they say? The employee's evidence was that people would want to only speak for the company's evidence in the sense that they would support the company because they wouldn't want to speak up. That wasn't found to be a viable response, and the evidence from the other attendees on the call that there was no such promise made was found to be valid and genuine.
It's a slightly off topic, but it's amazing to me, and I wonder how many legal cases come up where people have just misunderstood a conversation or just misheard or had their own idea of what was said.
That is an excellent point, and we're getting slightly off track, but it's linked in the sense that I find this by analogy with the investigation work that I do. I don't recall ever interviewing two people to the point where there's a difference in what was said. I'm relatively confident that no one has just barefaced lied to me about what happened. They genuinely have perceived a conversation to go the way that they are expressing it to be. And often you see in a mediation context where there might be some heated debate about what was said and someone says, no, you're lying, the mediator might properly step in and say, look, there could be two perspectives to this. No one's accusing anyone of lying here, but there might just be two genuine views as to what was said, and they're both genuinely held. So that's an excellent point, and this person may well have left that meeting with that view and understanding, ultimately not accurate or supported. But I got an example of this person, not necessarily, there's no suggestion that he just made this up, put it that way.
Well, he went out and found a software program that he thought would make him nearly $4 million.
Correct. And in response, and to your point about, well, where would he get this idea from, the CEO openly said that during this Teams call, he did encourage people to have a voice. He said, look, please come forward. If you've got ideas, we'd love to hear them. So there was definitely a solicitation, and that word was used in the decision, in the sense that the employee was alleging that by soliciting these ideas and benefiting from them, the company was unfair and not rewarding the employee for that. But by soliciting ideas is one thing, to then say you'll be rewarded financially without any metrics or parameters or what that would look like. So not surprisingly, when the CEO got the request for the payment, the relationship deteriorated, because at that point there was clearly a diverging of views, and the wheels fell off a little bit, because in refuting that there was any promise, the employee didn't take that well, and there was some claims about dishonesty or lying, and things went sort of south from there, to the point that led to the employee's resignation.
Right.
And as we've already talked about, when you're looking at the facts of who else was at the meeting, or there was a PowerPoint presentation that didn't talk about the profit share, and coupled with the CEO's evidence, the finding was there wasn't enough of a contract formed And it was a little reminder, the 5 things you need for a contract: offer, acceptance, certainty of terms, intention to create legal relations, and consideration. The important point, which you've made right from the outset, that can absolutely be done verbally. And while the promise in this case is rather unusual in the sense of it's extraordinarily large, think of a performance review where you say to someone, look, you didn't quite make it this year, but next year we'll definitely make it up to you. Or during the COVID times, we can't give you a pay rise now, but we will make good on that. That can be enough if it's clear what that means. If you go into more detail, like we'll make that up by filling a gap of X $1,000 and make sure that happens by this time next year, you may well have had a promise there, and if that manager leaves or there's some discrepancy, you might have already bound yourself. So that's the takeaway, is that the authority has said absolutely verbal contracts can be binding, and that's just something to put in the back of your mind when you're not maybe going too far and discussing these matters with employees.
But if it comes down, I mean, you're talking about performance reviews, for example, it's usually 2 people. So it could be a he said, she said kind of situation.
Indeed, which leads me to my final point, which should be no surprise, is that if you are absolutely following best practice, no problem making these promises, but always confirm in writing. Even if it's just a matter of recording in a file note or an email. Bear in mind, being a bit technical here, but the Employment Relations Act does require all employment agreements to be in writing. So not only is it best practice, it's actually a compliance issue to make sure that all your terms are noted. In that way, it's a helpful protection should something like this arise.
So can I just ask you one more question on this? If this employer had actually said, we will reward you if you do this, and if another employee on the call had corroborated that, would he be liable for $3.8 million?
No, you see, I think a couple of those elements of the 5 tests might be missing still. I think the certainty of terms would be the hardest hurdle, because here, just saying 10% would be a fair amount. It's too much of a stretch, unless there's changing the facts to some more enshrined process or percentage that everyone knows exists within the company and it's just a standard. That might be the case. But if it's just a Greenfields approach of offering some form of profit share or payment, there would need to be some terms about what that would look like. Otherwise, I think that would, the other elements of that, the 4 elements might be there, but the 5th would probably make it fall down, because there's just no way that they could reach the amount with any certainty. So
if an employer just said, we'll reward you, that really isn't enough to come back on.
Yeah, because I mean, that could just be like taking you out for lunch.
Exactly. Yeah. Carl, thank you very much for coming in.
Pleasure, thank you.
To support our award-winning independent journalism, subscribe to nbr.co.nz.